Sri Bibiano Sengki Widiantoro of the Faculty of Law at UAJY Yogyakarta University. We also have Head of Study Programs for Undergraduate Program Puspaning Tias Pali Purjati and Graduate Program Dr. Hieronymus Riti, Faculty of Law at UAJY Yogyakarta University. And also all the attendees include
Professor Stefen Koos, and I would like to read his curriculum vitae verse. Okay, Professor Stefen Koos, born in Hagen or Westfalen, Federal Republic of Germany. Okay, he used to study of law at University of Würzburg, Germany, and then 1994-1995, judge at the District Court Stadroda or State of Thuringia in civil law, agricultural law, criminal law, and guardianship law. Doctorate at University of Constance, Germany. Postdoctoral qualification, habilitation at University of Constance, Germany. Holder of the chair for private law and international business law at Bundeswehr University Munich, Department of Economic and Management. Okay, 2013 through 2015, temporary consultant at the World Bank. Since 2016, economic collaboration with the Business Law Department of Business University, Jakarta. Since 2011, visiting professor at the Law Faculty of Universitas Islam Riau, Pekanbaru, Indonesia. And since 2017, visiting professor at the Law Faculty of Universitas Airlangga, Surabaya. 2022, adjunct professor at the Law Faculty of Universitas Airlangga, Surabaya. There are some recent publications. Some of them are in Digital Globalization and Law, Introduction to a Social Approach of the Indonesian Consumer Protection, Artificial Intelligence as a Disruptive Factor in the Civil Law, the Individual and the Property in Virtual Worlds, and some more. All right. Today's topic, I have said before that we have our today's topic, the introduction of data protection law. Akan menyampaikan materinya baik dalam bahasa Inggris maupun dalam bahasa Indonesia. Jadi dapat mengajukan pertanyaan juga baik dalam bahasa Inggris maupun bahasa Indonesia. To the Honorable Professor Koos, please.
Takut ya, 2 jam 15 menit, 1 jam 15 menit ya, itu cukup ya. Nanti ada tanya, itu mungkin 2 jam semua, tapi tidak 2 jam berbicara sekarang ya. Dan saya coba campur, tapi saya tidak bisa janji, saya bisa di bahasa Indonesia itu. Ya, saya punya sedikit masalah dengan topik itu. Bisa mulai presentasi? Karena saya punya preparasi untuk artificial intelligence dan yang lain. Oh no, ini, wait. No, yang lain. Sudah ada di stick. Dan saya percaya protection law. Tapi saya action data pribadi introduction karena itu penting untuk Anda. Ada di sini regulasi, akan regulasi nanti dan mungkin kita lihat bagaimana nanti ada mungkin waktu atau tidak ya. So mari kita mulai. Next one. So I have it here myself ya. Yeah? Oh, I forgot. Yeah. Belum. Data protection, perlindungan data pribadi, itu konsep nanti ada di Indonesia regulasi. Itu regulasi itu untuk mengerti regulasi ini penting tahu tentang experience data protection di Eropa, di Uni Eropa. Kenapa? Karena regulasi ini di Indonesia punya sebagai contoh regulasi perlindungan data pribadi dari Uni Eropa. Ya, so di sini ada ini contoh bagaimana penting legal comparison. So normally saya sudah berbicara tentang legal comparing. Normally, I don't think it is so important to know about foreign law and any detail of the foreign law here in Indonesia. So when I give my lectures in Indonesian universities, normally I don't like to speak about some issues of the German law or European law if it's not important for you. But here it is important for you to know that, karena konsep itu sama seperti konsep di hukum perlindungan data pribadi Indonesia. Ada? Is it there or not? I put it to the stick. It is in USB. No, ini not. This one is the one from the morning. Go to the just to the yeah. Data protection on Atmajaya. This data protection. Ini. Ya, tapi itu PowerPoint, right? No, this is the. Wait. Ya, this is good. Sorry, saya bingung. Itu betul. Ya, sorry ya. Oh ya. So now to the presentation. Yeah, I'm sorry. Yeah, technical problem. So let's start with some basics of it. Not possible. Oh, no. And the personality right effect of the data protection for the individual. So what we need is to assign responsibilities and duties for monitoring, for controlling, and for tackling problems for data security in the companies, and that needs structural and responsibility issues like awareness within the company, that the data protection is a top level priority. This is everything the same, right? If we talk about the due diligence of social responsibility, of course, social responsibility is an issue. But if we see how it is seen in the companies, sometimes we see that the companies don't take it serious enough, and the same will happen to the data protection. Then we need the description of the data protection goals. That will be especially important if we see the ambivalence of data as an economical good on one side and on the other side as a good for protection. Then we need to determine the responsibilities. Who is responsible in big organizations? This is always a problem. I mean, you are responsible for behaving and for complying with the law. But if we have big organizations like big companies, who is responsible in the organization? And this is, anyway, always a big topic about who is responsible, how we share responsibilities in big organizations, and how we delegate responsibilities to the structures and to the company structure and also the organization of the company. Then awareness of data protection risks and the transparency about conflicting goals. And for the European Union Data Protection Regulation, we have this regulation since 2018, the GDPR, the General Data Protection Regulation. So, without having a regulation in Indonesia in the future, the data protection regulation of the European Union is already important for you here, if you have a company. Why? Because this data protection regulation already was extraterritorial applicable. This means if you have a company and you process data of European citizens, the data protection regulation of the European Union is applicable to your company. This means any student nowadays already, until now, should have learned about data protection law in Europe, but also, of course, in the United States, because all these data protection regulations are potentially extraterritorial applicable to companies. Because, as I said already in the morning session, because in the ubiquitous world where something happens in the internet, we don't have only territorial assets, cases. We have ubiquitous cases which happens in the whole world, and what happens in Indonesia can happen in Europe, which happens in Europe can happen in Indonesia, and we have citizens which are moving in digital worlds and are influenced by data protection issues, even from companies abroad which have their seat not in our own territory. And this is very important. And so we have to know about that. And so, as I said before, the data protection regulation in Europe is a good example for learning about the experience, how to apply the future Indonesian data protection law and which problems will arise in the future, maybe. However, saya harus bilang, saya tidak translate draft in the regulasi Indonesia, saya belum translate untuk saya. Saya tidak pernah lihat draft itu sendiri, tapi saya sudah lihat dan saya sudah baca beberapa paper tentang draft ini. But I don't talk from my own side. Yeah, I don't know much about this draft yet. Yeah, but I know which problems will maybe arise in the future. So these are the 6 fundamental principles. If you learn about data protection, and that will be the issue also in the Indonesian data protection law, you learn about 6 fundamental principles which in the GDPR in Article 5. First, legality and transparency for the affected person. Every data processing must be legally founded, and must be transparent for the owner of the data, for the citizen whose data are processed. Second, the use can only be for a determined, clear, and legitimate purpose. This means you cannot just collect data and store the data in case you make a new business. If you want to collect data and process data and store this data, you must, before you do so, define a clear purpose why you collect this data and why you store this data. You must define the purpose. And the purpose must be clearly defined, not like making business. This is not a purpose. You must clearly define, I need this data for process, for example, current contracts I have with the customer. As long as I have the contract with the customer, I can store the data. Once I don't have this contract anymore, I must delete the data because the purpose ends. This will be, in Indonesia, a problem for small companies. Yeah? Because these small companies will have to define for every data storing this purpose. Third, minimizing of data to the necessary amount. This is related to the first, to the point before. We cannot collect data because in case we need them maybe later. More data the better, the more I know. We must minimize data. If the purpose is defined, we must minimize the data storing and the data processing to exactly that purpose. Then accuracy of data, of course the data must be accurate, must be correct. Limitation of storage to the strictly necessary time. This is, for example, a problem for academy. I'm a lecturer in a private academy in Munich, and if it comes to the storing of the data of our students, how long can we keep the data? Yeah? If there's a purpose for it, for example, the students can maybe some years later come and want to have a proof of their examination, and we define this as a purpose, maybe it's possible to keep this data. But if we say we don't have the duty to give the proof, let's say after 5 years, longest, then we cannot store the data after 5 years, so we must delete the data. That leads to the problem that after 5 years nobody can ask for a proof because we don't have this data anymore. So a clear limitation, how long we can store the data, which is the time for storing it, and if the time is over it must be deleted. And of course integrity and confidentiality of storing and processing these data. So important is for the data protection, especially in the companies, that the responsible party has the burden of proof that there is compliance with the data protection requirements. Without having seen the draft in Indonesia, I suppose there will be the same issue in the Indonesian law. Because it doesn't make sense if we don't have the burden of proof to the organization or the company. Why? Because the citizen has no option to prove that there is a breach of trust or a breach of security. We don't have an insight to the organization. And I always a fan of teaching the students that they should not learn law just from certain topic. I mean, if you sit here in data protection law, you should not learn only data protection without seeing the rules and the, let's say, the ideas behind it, which are umum, which are general and comprehensive for all the law. If you see this burden of proof issue here, the compliance with the data protection requirements and the proof, the burden of proof, then you can see that this is actually a general rule. Wherever we have a, let's say, organizational responsibility, we will not have a law which is easy to enforce if we don't make the burden of proof to the one who has the organization. If we cannot assess that some individual person is responsible for a certain aspect of a breach of trust or a damage repair issue, we must give it to the organization. But if it's an organization, there must be a proof how they organize it. That's why we call it an organizational guilt. Organizational guilt is the failing of organizing a certain organization in a way that damages are avoided. And of course, this can be only proven by the organization itself. So this is not only in the data protection like this, it is everywhere like that, where we have liability of big organizations and we cannot give certain responsibility to a certain person within this organization, but we want to make the organization liable. Organizational guilt. And this is actually a legal aspect which is not only in the data protection law. So the key aspect is increasing the rights of the affected person, affected by a breach of trust or a breach of security, accountability, make the organization accountable for that, and data security and visibility of data breaches, make the organization that data breaches are not hidden, but can be seen, can be found out easily, and can be, of course, tackled. This means if the organization is not giving the possibility that data protection breaches are understood by the public or by the titular of the data, then the organization is not correctly. So this is what I mentioned already. This is the same, will be the same in Indonesian law. Extraterritorial application of the data protection law means when I, for example, work in an Indonesian university as a guest professor and I take an examen and I have data of Indonesian students, then I'm under the Indonesian data protection law in the future. If Indonesian university works together with me as a guest professor and has data from me in their data banks, they are actually processing my data as a citizen of the European Union. Means it is under the European Data Protection Regulation. And this extraterritoriality is also a comprehensive issue, which is not only in the data protection law, which you must understand as an issue of international law. Basically, maybe one of the most important aspects of the international law, to understand what is extraterritoriality and what has it to do with international law. Because extraterritorial application of national law means actually we introduce with our national sovereignty into the territory of other states. Right? Is that fair? What do you think? Is that fair? It's not fair? It's arguable, yeah? In the international public law, we would say we take care of the sovereignty of our neighbors, yeah, and of the other states. This is actually the idea. And that is what I mentioned in my lecture always. We have a crisis of the international law. It's arguable, but actually it's self-defense of the state, because the state has the duty to protect me as its citizen against infringements from abroad. And if we have ubiquitary society without territories in the internet, How the state should protect me if not like this, right? So this is why I say we have a crisis of the international law, because we have more and more legislations which are extraterritorial applied. Like in the antitrust law, European Union is fining agreements between companies doing the agreement in Malaysia, because the products which are under that agreement come to the European market later than other products, so it is influencing European market, so we apply our law extraterritorial. Something like this happens here also, and the question is, how valid is it? How will it work? European Union data protection regulations prove that it works excellent. We can say that even the big US platforms are respecting the European Union data protection regulation. Mr. Zuckerberg's speaker, she said some months before, actually we think about leaving the European Union market in the future because we are not able anymore to fulfill the duties of the European data protection law. And do you think the European Union politicians and functionaries were very worried about that? No, nobody was worried about that. Oh God, we don't have Facebook anymore. Oh, and Instagram, oh my God. No, the commissar for that said, okay, may they go, but we don't think they will go because our market is very big, yeah? The common market is very important. And so they will adjust, and this is always the same. They always say, oh, we cannot, we will not. And then in the end they comply. That is what Alphabet, what Google does. This is what Microsoft does when we have antitrust cases where Microsoft is involved. They pay billions of euro fines because they comply with our rules. And the same will happen with Mr. Twitter, Mr. Musk. Yeah, Musk bought Twitter. Musk said, we will make Twitter free. We let Trump come back. We will make hate speech is all free, and let's be free speech and free opinion everywhere. And then even if it's maybe infringing the law of Germany or of European Union, he will not care. Will he not care? I don't think he will not care. I think he will care because Twitter needs advertising, yeah? And if the companies are not wanting to be in Twitter because it is a dirty platform, then it is economically not good for him, but they will comply because they need our market. And the same will happen, I think, with Indonesia, because don't underestimate Indonesian market with 280 million people. This is a vast and a big market. So many people think, oh yeah, Indonesia, yeah, they can make that and nobody will respect it. I think they will respect because your market is at least so as important like Australian market. And Australia already won the fight with Zuckerberg. So this is the issue of that, yeah, international transfer, because we want to protect our citizens. It's not allowed to transfer data from European citizens to abroad, to third countries. European Union countries are safe, but if I use Zoom in Germany, I have a problem because Zoom has servers in the United States. United States is not member of the European Union, so if my students are logging into the Zoom lecture, their IP data are sent to the server in the US, and this means I don't comply with the European data protection law. In the pandemic, I was forced to use Zoom because I didn't have anything else. So actually, I had the choice between complying with the law and then stopping my activity as a professor, or not comply with the law, breaching the law, breaking the law, yeah, and do my task. Yeah, and that shows the problematic. Yeah, so if the third country is safe, you can transfer the data. If it's not safe, you cannot. Safe is Singapore, safe is Israel, not safe is Indonesia, and not safe is US, because the US government, until now, did not guarantee that they will not take the data of European citizens, even in case of a national security incident. Yeah. We will have a negotiation with the US now, and they plan to make it safe, but in a moment not. So, general principle for data transfer to third country is two-step. It must be justified by consent or legal provision, and there must be adequate level of data protection, and that is in many, many countries not. I think around 7 or 8 countries are safe. Norway, I think, also, and so on. So, What is the material scope? The material scope of the application, and that is all the same of Indonesian law. So this, what you learn here, you can use for Indonesian law also, and then in the end I will talk a little bit about Indonesian law also, is the processing of data wholly or partly by automated means, other by automated means which form part of a filing system or intended to form part of a filing system. And the processing is any operation, whether or not performed by automatic means, collection, recording, organization, structuring, storage, adaptation or alteration, retrieval, consultation, use, etc. So everything, significantly wide definition, everything is actually data processing. Even if you think about things like in the cyber notary, the digital signature, this is also a data protection issue, because in the digital signature, there is also private data which are individualizable, and if you send this signature abroad, that is a data protection issue. So, or in the cookies, of course, the cookies are a data protection issue. You know, this is all falling under the regulation. And the basic premises of the data, I already mentioned that, is the justification, the agreement with the user, with the owner of the data. Is there setuju, is there allowance to use it? Transparency, purpose, limitation, data economy, technical, organizational measures. This is very important. This is the data protection by default and data protection by system. For example, in the conceptionizing of the concept of the instruments, for example, you buy a smartphone or augmented reality glasses, it must be technically already have the concept that it is not potentially infringing the rights of the data protection. So this is the privacy by design. And new is the principle of the good faith, and especially important is the risk assessment and the accountability, which impose a lot of duties to the companies and to the authorities. And that will be a problem, and it was a problem in Europe for small companies, for small associations, is also for private persons who make business, and that will be a problem, of course, in Indonesia. If there's no waiver for small companies, because the small companies have, as I know, 2 years' time to adapt to the new regulation, and it will have a lot of duties for risk assessment and monitoring it. So, which are the obligations of the parties, of the responsible parties? Lawful processing of personal data, implementing appropriate technical organizational measures to ensure and demonstrate the processing of data in compliance with the regulation, record of processing activities. They must always be able to prove what activities they did and how they make the security for these activities. Security of processing and data protection impact assessment when there is high risk. If there is a high risk use of data, then they must be able to make this assessment before they make the procession. This means you must make a risk assessment. How risky is it if we implement this data protection issue into our organization, and must be able to prove that they make that assessment in a way to assess how risky it is indeed. Then if they don't do it, this is a breach of the law. And what is personal data? This is already a little bit problematic, because the European Union also has a regulation about free movement of data within the European Union, machine data, for example. If it's personal data, it must be at least identifiable. So there must be at least an option how to find out whose data is it. For example, if you drive a self-driving car like a Tesla or one of these new Mercedes which have a self-driving opportunity, then this car is all the time collecting data when it drives, right? So telemetric data. So this telemetric data on the first side are machine data, but on the other side you can find out whose car is that. And that means it is identifiable, so it would be personal data. So everything which is identified or identifiable is personal data, which makes the application of the law very wide, of course, and makes it very difficult. And I heard when we talk about Tesla, I read in the news that Tesla is not allowed, or users of Tesla cars are not allowed anymore to enter the German army places. So they cannot enter the Kaserne and these military areas with their Teslas, because the German army is afraid of the camera function of the Teslas, because there could be a breach of security by using a Tesla in the ground of the German army, where they have the tanks and where they have the weapons and all this. So you see the problem of this self-driving car. And the reference to the person, yeah, vehicle data, of course, yeah, machine data, consumption data of photovoltaic systems, and so on and so on. There you cannot exclude that the reference to a person is given, and that means it makes it to personal data and brings it under the scope of the regulation. And the lawfulness of the data protection, and then we come to the more interesting economical aspects later, is the consent of the data subject, which is already difficult. Yeah, the consent is already difficult because when you have really a consent, I try to take the consent of my students when I make Zoom meetings by just, if you enter that Zoom room, you consent with the data processing. But already if you see that the students must be able to attend my lecture, means when they enter, they not agree with it. They just force to enter, and forcing to enter is not agreeing. So it is not really agreement with the data protection issues. They want to just attend my lecture. So this is problematic. Then it must be necessary for the performance of the contract or to take steps prior to entering into a contract. Then it must be compliance with legal obligation. Or it must protect with vital interest, then you don't need the agreement. Yeah? If it's for performance of a task carried out in the public interest also, you don't need agreement. But teaching for my lecture is not falling under it. So this is very interesting. I was not allowed to do it without consent of the students. Or it must be necessary due to a weighing of interest. We cannot go into that. This is actually very interesting, but we don't have the time for going into this too deep. And this is interesting because Indonesia did not make that, is the concept of privacy by design and privacy by default. Why is this important? If you talk about, do you know about dark patterns, what dark patterns are? Dark patterns is one of the most interesting assets of the consumer protection law. Why? Dark patterns are mechanisms, especially in web pages, which influence the user in a way to make decisions or to make business actions which otherwise he would not have done because he does not really understand what happens here. So it is subliminary influencing of users. What could it be, the dark pattern? For example, a dark pattern can be if you make something very intransparent and the user has a different idea about what happens. Or if you talk about the cookies can be a dark pattern. For example, if you make the cookie and you make an overflow of information what the cookie must. I mean, how you handle cookies. You know what cookies are, yeah? You are entering the web page, then there comes the cookie, and then the cookie is a data protection risk. Why? Because the cookie collects data of you, when you visit the web page, how long you are on the web page, and so on, and then the cookie will know next time you come back, oh, this guy is very often on our web page, maybe he buy more, maybe his willingness to pay is higher, so we can offer him more expensive or something like that. So actually you must agree with the use of the cookie because of the data protection regulation, right? Because it is a processing of your data. So you will have the cookie, and then the cookie will ask you, are you agree with the use of that cookie? Before you not click yes, you cannot enter the web page. And if you not click yes, then the cookie will inform you what it does, right? You say no, you cannot enter. You say maybe, and then, but I want to know what it does. And then you get a lot of information what this cookie does. But if you're not an informatic person, you will not understand what the cookie does. So what I do, and I'm a data protection guy, I just click yes. I don't care. And this is dark pattern, because you overflow the user with so many information that the user is too lazy to read that. And they know the user is too lazy to read that, so the user will always agree, and then you have agreement with the data processing. This is a dark pattern, because actually, maybe you don't want to use the cookie, but they make you use the cookie because you are too lazy to read what the cookie does. So this is the question of the information overflow, and this is a sort of a paradoxon, the privacy paradox, the more dangerous something is for the user, the less the user want to know about it. This is the privacy paradox. Now, dark patterns are addressed in the new regulations in the European Union, especially in the new Digital Market Acts, which comes next year, and in the new Digital Service Acts, which comes next year. The Data Market Act is regulating certain aspects of the market structure in digital markets, and the Data Service Act is addressing certain aspects of security, safety, protection of the users in digital surroundings. For example, children protection, but also, again, hate speech, something like that, also cyberbullying and those things, and especially also dark patterns. So it is addressing dark patterns. It says that certain dark patterns are forbidden if it influences the user in a way the user does not understand correctly. And this is also, of course, a data protection issue, the dark pattern, because the setuju is not there. The agreement is not there, really, yeah, because the user does not understand what happens here. Now, how will Indonesia handle dark patterns in the future? The data protection law is not containing privacy by design and privacy by default. First of all, we must understand what is that. See, this is Article 25, which is talking about privacy by design and by default, taking into account the state of the art, the cost of implementation, and the nature, scope, context, and purposes of processing, as well as the risks of varying likelihood and severity for rights and freedoms of natural person posed by the processing. The controller shall, both at the time of the determination of the means for processing and at the time of the processing itself, implement appropriate technical and organizational measures such as pseudonymization, which are designed to implement data protection principles such as data minimization, ineffective, and so on and so on. And then in the second it says the controller shall implement appropriate technical and organizational measures for ensuring that by default only personal data which are necessary for each specific purpose of the processing are processed. What does that mean? It means you must already design a web page or a service or an instrument or an item in the way that this is not collecting more data than necessary for the service or for the use of the item. So an item which is open for sending a lot of data and collecting all the time data, even if these data are not necessary for using the item or the service, would be an infringement of the data protection by default. So by default, it must be sure that the user is not giving more data than necessary. And if you have a dark pattern, which makes the user giving the data free out without knowing what happens, is not privacy by default. By default, it must be you can enter the page without giving the data, without being influenced. And as I understand, the Indonesian draft is not containing expressive regulation of privacy by design and privacy by default. This means with the data protection regulation of Indonesia in the future, you will not be able to address properly the dark pattern issue. You can do it maybe with the consumer protection because it could be misleading information, but this is not yet defined, and this is not yet discussed in Indonesian law, how it is misleading information if you give too much information. So this is a paradox, right? We give too much information and mislead the consumer by giving the information. Actually, we should give information, but we give too much information, and the problem is not yet solved how we can make it in a way that it is not misleading, giving too much information if technical issues. Yeah, should we not give the information about the cookie? Should we forbid the cookie maybe? Should we make a red light, so red, yellow, green? So, oh, very dangerous, then it's red, the consumer knows I should not give the cookie or whatever. This is not clear, this is not defined. So actually you can address it best with the data protection, but only if you have this issue with the data protection by default and by design. Something which we have in the Indonesian law also, we have also in the European law, is the damage repair in breach of data protection issue. In Article 82 in the Indonesian law, it's also implemented, but I forgot the article, which is going, and this is important also, yeah, it's also comprehensive for all law, the differentiation between material and immaterial damages. What is a material damages? Very easy. If I have a level of property or a level of ownership, of property, of rights, everything which makes the value of what you have, and I see what I had before the damage happened, and I discount it from the situation, discount the situation after the damage, then we have a difference. And this difference is a damage. For example, if I destroy your phone, before you had a phone which has a certain value as a pre-owned phone, if it's destroyed, the value is less because someone must repair it, and the difference between the value of that phone and before and after, this is the damage. But how we assess the damage for the damage repair in a breach of data interest? Yeah, sometimes we can assess it, because sometimes we can say if the data, if there's a data breach of data, it destroys maybe the opportunity to fulfill a contract or something. We can say that. But often, and very often, especially with private people, it will be immaterial damages. Immaterial damages are subject of the data protection regulation and will be surely also subject of the Indonesian data protection regulation. But what are immaterial damages and how to assess them? And this is something you must know in everything, not only in a data protection. If you know about civil law, you must understand that. And this is a very difficult aspect, because immaterial damage is, for example, if you hurt me, I go to the hospital, I have cost for the doctor and for the healing, and I cannot work. This is material. But I had aching, it hurts me. And actually I hate you now because you hurt me. So I want to have this vengeance idea, right? This is immaterial. And the German law addressed that with the so-called Schmerzensgeld, the aching money, the hurting money. Schmerzensgeld is something which is not material, but is more giving me, we say it in German, Genugtuung, giving me the feeling, now it's fine. And immaterial good, we have also in the personality right infringements. In the personality, interesting enough, because that is close to here. If there was a case in the 50s, a professor of theology, I think Catholic theology, was mentioned in an advertising for red ginseng. And the advertising was talking about sexual function and stamina and I don't know what. And this professor of Catholic religion was not happy be mentioned as someone who is promoting red ginseng as a stamina. And then he claimed, because of infringement of his personality, yeah, and many cases like that. And in that time, we did not know, in the 50s, we did not know how to make the damage repair, because there was no material damage. It was actually immaterial damage. So is it Schmerzensgeld or not? And this cumulated with other cases in the 80s. Was a case of a prominent Fürstin Monaco, there was a principality of Monaco. She was also used in the news and in some article of some journal. And she got 50,000 Deutschmark because she was infringed in her immaterial interest as a person, because they lied in that journal article about something about her, and they invented some interview she never gave. The issue is very often very important. If you go to the anti-discrimination law, for example, anti-discrimination law, let's see, I discriminate you, I'm the boss, you are seeking for a job, you're applying for the job, and you are looking like someone from Asia, and unfortunately you are a man, let's say you're looking like someone from Asia, and you're a woman, yeah? And maybe I don't want to discriminate you, but in the job interview I ask you, by the way, where are you from? And then you say, I'm from Indonesia. Oh, yeah, nice, yes, yeah, I made holiday in Indonesia last week. And then you don't get the job. What you can do in the German and the European anti-discrimination law, you can claim that you were discriminated. Now, first of all, it's the question of the burden of proof. The burden of proof is on the boss. I must prove that I did not discriminate you if there is a hint for discrimination. And the hint for discrimination is that I ask you for your ethnical background. This is the hint. If you can prove that I asked that, I have the burden of proof that I did not discriminate, and I can never fulfill that burden of proof, right? So this is one issue. But the second, the more interesting issue for our topic here is, what is your damage? That you not get the money from the new job is not the damage, because you had the chance to get that, but it is not in your property already, yeah? So there is no material damage. But on the other side, how we end with discrimination if nobody ever have material damage and the damage repair is not working. So we need immaterial damage, and that is what the law says. The law says you have the right to claim for immaterial damage of 3 monthly salaries, but if I cannot prove that without discrimination you also would not get the job, it is the sky the limit. Can be theoretically 24 monthly salaries. Even if you never had the right to that salaries, that would be the damage repair of the immaterial damage in order to prevent discrimination in the future. And that is the purpose of immaterial damage in the data protection too. It should be expensive for the companies to not fulfill the duty of the data protection law, because if it's only material damage, then many people will not claim because it's not worth it. And then there is no sanction for the breach of the data security. And this is, by the way, very important to understand, because if you talk about corporate social responsibility in Indonesia, you have corporate social responsibility rules, but what is the sanction? I think there is no sanction, right? It's just the companies should fulfill the duties of the corporate social responsibility, should be responsible and so on. But if not responsible, and someone proves, oh, they did not make any organization to be responsible, there's no damage repair or no sanction. If no sanction, nothing will happen. So the sanction must be hurting the companies, and the immaterial damage will hurting the companies. So the question is there material threshold in immaterial damage? No, there is not. And what is the burden of proof? Interesting enough, the burden of proof is also discussed. We don't know yet whether the burden of proof is on the company or on the one who makes the claim. But we think it must be on the company, because the one who makes the claim cannot know what happens within the company. So the burden of proof must be on the company. This means it will be very parallel to the anti-discrimination law, and that can be very important and very expensive for the companies. And more expensive will it be once we have the European class action. In the moment, the German law does not know any class action, so anybody has to claim individually. But in the future, we will have the opportunity for class action everywhere, and that will be very expensive, because then we collect a lot of data infringed citizens who claim in the class action against the company and make it very, very expensive, and then the incentive for complying with the rules will be very strong. So now we come to more important, or not more important, but also interesting. I just want to make that relatively short, because I want to show you the ambivalence of data, actually, because we talk only about something very classical, data protection. Data protection in the prohibitive way. First of all, my idea is that data protection in the prohibitive way is not enough. Yeah? Second, you cannot understand data protection law without knowing about antitrust law. You cannot understand it. And you cannot understand data protection law in a modern way without knowing about economy. Why? Data play a big role in the digital economy, because data collected by undertakings, especially by big platforms, can be a market entry barrier. If you see, for example, GoCar or Amazon or, I don't know, Apple, they have a lot of data collecting, and especially if we see the situation of, I don't have that here, the situation of Amazon. Amazon is a multi-sided market actor. Amazon has a platform for selling to the end user. Amazon has a platform for selling for other sellers. They can use the platform. And Amazon also have other businesses, and they have also a cloud system. So they collect data from their selling their product to the end users, but they also collect data from the companies who sell on the platform, on their marketplace, and then they can exchange the data between the purposes. This is already a data protection problem, because if I buy in Amazon, I not agree, or if I buy from another company which use the platform, I don't agree that Amazon use this data for their own business. Yeah? Data sparing aspect. But what if Amazon wants to make a new market? And they are not ready yet. For example, want to go into the telemedicine. They can use this data for the telemedicine, but maybe they're not yet ready. But maybe we have a platform who has already telemedicine platform, but they don't have the data. If Amazon now wants and close the data to other companies, then they can avoid that a new neighbor market is opening, because the cost for collecting this data is very high, and the other company don't yet have the data. So the question is, do we have to make interchangeable the data to other companies to open the data stock to other companies to open markets, because in digital markets we have the tendency to monopoly, especially because of the stock of data, which is very easy to keep and to close out for other market participants. So data could be an essential facility for other markets. And the problem of the data in the economy is very interesting, actually, because some people say, data adalah minyak abad 21. Is that correct or not? This is nonsense. Data are not the oil of the 21st century. Nonsense. Why is this nonsense? And this is why I say you must know a little bit about economy. This is nonsense because oil is limited. If we have a limited offer of something and we have a high demand of something, like nowadays, the oil is expensive. If we have a high offer and a limited demand, the asset is cheap. So the evaluation, the assessment of the value, the pricing of a good or of an asset is depending on demand and offer. But data are not limited. Data are not rivalrous. This means for example, I use WhatsApp, I use Instagram, I use Twitter, I use Apple. So they all have my data. So I can decide to whom I give my data. Whether I give my data to all or not to all, depending on the attractivity of the platform, and sometimes also on the lock-in effect. For example, Apple could say, just use all our services and don't go out because we are safer, and then I'm in this Apple universe and maybe I don't want to go to other platforms because I'm already in the universe. This is why I say the monopolistic structures of these markets must be tackled by opening actually for the user the opportunity to change platforms. If the user can change platforms, he can give the data to anybody. But you see, it's not rivalrous. So if it's not rivalrous, how we want to assess the pricing for it? And second, the ownership cannot be erga omnes. It cannot be that we give the data free as a property for a company and the company can do what they want with that. That is very important. And why is this important? Because you see here, and this is interesting because you see here also a systematic problem of regulation. We have a lot of regulation in the European Union about data, and we have, as we see already, the Data Protection Act, the General Data Protection Regulation, but on the other side, we see the EU Data Act. The EU Data Act asks who can create value from data and under which condition he can do that. So these are rules to ensure fairness regarding the use of data generated by Internet of Things. For example, if you wear your Apple Watch, you all the time walk around, the Apple Watch sends data, there is a lot of data points, or if you later use the metaverse, it will be the same, they will know whatever you do. And I can tell you, we even know how often you are in your ATM or how often you come close to a bank. And if you come often to a bank, it means you need more money, can mean you need more money, or can mean you have much money. Means maybe an AI system can maybe assess whether you are willing to pay a lot of money because you all the time take money from ATM. At least you are willing to use your money, right? So you can know something about the people. These IoT data are important. These are a value. Who can make a value with it? The platforms make the value with it. They combine with other data, with other information, and then they can make a product because they can make a filing for you, for every individual in the world, and can use this for advertising and give it to other companies, of course. So the question is, who is the one who should use that? Is it the platform, or should I have, as the person, have the right to get my data back? And this regulation is about that, which is a new regulation which comes into vigor later. This is the draft regulation on harmonized rules for fair access to and use of data. And this is so important to know because you cannot understand data protection law without understanding that. And this says that it lays down harmonized rules on making data generated by the use of a product or related service available to the user of that product or service. So you use the product and then you produce data. Compare that with mining. You are a miner, you are a tin miner, you have a tin mine, you produce tin. The tin is sold and someone makes something out of that. So if you talk about oil, the one who used the Internet of Things, the one who used the Apple Watch or the Huawei watch, That one is the miner. You mine the data. You mine the ground product, the raw product, and then you give it to the refinery. And the refinery is Mr. Zuckerberg's company, for example. Yeah? They refine it. They use it, they produce it, they make something, they combine it with something, and then they have a very interesting package about you and can sell it to anybody if they want, if it was not illegal. And the regulation says products shall be designed and manufactured and related services shall be provided in such a manner that data generated by their use are by default, here we have it by default again, easily, securely, and where relevant and appropriate, directly accessible to the user. The user should access directly, be able to access directly these data which are collected by these things by default, and if not, then the user has the right to have made available to him the access to the data. And this is very interesting economically, because what does it mean? It means the data are property of the company, and the user has the right to do that, but is that an economic function for the user? Do I have the right to use this data economically? I'm the owner of my own data, or who is the owner of the data? And I don't want to go into the deep, but I just want to show you this sentence from Article 4. It says, the user shall not use the data obtained pursuant to a request referred to in paragraph 1 to develop a product that competes with the product from which the data originated. So I ask the company to give me my data, but I'm not allowed to use this data to make business with this data. Obviously, we have an economic function of the private data in the hand of the user, because otherwise that would be a potential competitor. It's very interesting. So, this is the other aspect, very important. The European Union regulates data as a counter-performance for digital services. So, it shows again, the data have an economical function. If you using Instagram, is it gratis? Whoever say it's gratis does not yet understand that concept, because it's actually not gratis. It is not gratis because you give them your data. And they are interested in the data. And if you know a little bit about digital markets, then you would know that, and you cannot know that, of course, because you did not yet do that, but if you know about digital markets, you will wonder that there are a lot of services which obviously are not taking money. And we ask ourselves, why do they do that? For what? You can only understand that if you understand how digital markets work. Digital markets work with the hen and egg principle. What does it mean? What was first, the hen or the egg? What was first? The platform users or the platform offerers? So we have a platform. Imagine you make a platform. You want to make an online selling platform, new platform. You want to make concurrence to GoCar and GoPay and GoFood and I don't know what else. Who would use your platform? If you not have enough sellers using your platform, for example, like in GoFood, not enough restaurants participate in it, nobody will order food in your platform. On the other side, not many restaurants will, or not many companies will join your platform if you not have many users on your platform. But the users will only come if many companies are there, and the companies will only come if many users are there. This means platforms must grow extremely fast and must extremely fast build a big stock of users, because otherwise the platform is not interesting for the counter side of the users. And this is typical for digital markets. And because that, digital markets or digital participants in digital markets must grow extremely fast, building a stock of users, because otherwise they will not be able to be successful in the market, because the other side will not use the platform. And this is the same idea which leads to monopolistic structures, because of course the platform is only interested if they have a big stock of users. And then they're already so strong that they can exclude competitors from the market, because it's very difficult to have this stock of competitors, but of users. But once you have this big stock of users, you can do whatever you want, and it's not expensive. So GoPay can, of course, add GoPijat, Go Cleaning, Go Nanny, and I don't know what else, yeah, because they have already the stock of users. It's not difficult to upset and to widen the company and the business. And this is so important and so interesting, because it shows that they do that not for free. They do that for growing fast. And they need your data. And in many issues, we don't understand really what happens. For example, WhatsApp. Why do you think Zuckerberg bought WhatsApp? You think he bought WhatsApp because of the data of the person? No. WhatsApp is bought by Meta because he did not want to have the data. He knew if he collects the data from WhatsApp, then the American antitrust authorities will forbid the merger. Definitely. No, he could easily go to the public and say, don't worry, tenang saja. Kami tidak akan menggunakan data WhatsApp. Kami tidak pernah akan monitorize WhatsApp. Tenang saja, tidak masalah ya. And he means that. Why? He wanted WhatsApp just to switch off a potential competitor. This is a killing acquisition, yeah, nothing else. But actually, in other cases, they really need this data. And these data are a payment. And the European Union says, this could be a counter-performance, but the problem is the monetary evaluation of the data and the personal rights of the individual. What is the monetary value of your data as an individual? You cannot go to the market and say, hello, here I am, here my data, give me $1,000. Nobody will buy that, yeah? Or is the data, if it's a counter-performance, is a payment? Do we pay with our data? Then is data money? It's not issued by a state, right? Is it 1 dot or 2 dots, or how many dots is it? This is very difficult to assess, and this is indeed a problem, and this is regulated in the Digital Content and Digital Service Directive, which says, which wants to harmonize the consumer contract regulations concerning contracts about digital content and service, and says in Article 3, consumer provides personal data in return for the entrepreneur to provide them with digital content or digital services. If it's not used exclusively for contract performance, means you give your data for purposes which are not exactly belonging to the counter performance. It is giving them something to use to make them happy that they give you the service. So instead of paying money, you pay data. This is the concept of the European of the directive here, which is indeed also regulated in Germany, and it's regulated in this article in the German Civil Code. It says, the provisions of this subtitle shall apply to the consumer contracts which have as their object the provision of digital content or digital services by the trader against payment of a price. This is first of all interesting for Bitcoin. It says, for the purpose of that subtitle, price includes a digital representative of value. What is this? This is Bitcoin. Because Bitcoin is not money, so you don't pay, when you pay with Bitcoin, you don't pay with money, you pay with a digital representation of value, because we don't have a category for Bitcoin. But interesting is the second one, provisions of that subtitle shall also apply to consumer contracts for the provision of digital products, where the consumer provides or undertakes to provide personal data to the trader. Many problems coming up with that, especially when is the contract formed? Yeah, if I pay with my data, so if I open an account in Meta or in Instagram, for example, and the payment with the data is the counter payment, so when is the contract formed? Is the contract formed when I agree with a cookie, for example? So cookie could make a data contract, right? So I agree with the cookie, then they say, oh yeah, you agree, so you pay with your data here, we can collect your cookie. I talk about dark patterns, right? No, cookie is only consent for the data protection reason, but this is not enough for saying I want to be legally bound in a contract if I agree with the cookie. And again, this is something you cannot address yet in the Indonesian law, and a little bit you can address it in the European law. The contract requires an active choice by the consumer about the payment. You must know you pay with your data. It must be clearly given the information that if you agree here, you pay with your data and you get the product because of your paying with the data. And the classification is not clear. So even the data protection commissioner, coming from the data protection side, you see data property and data protection. This one coming from the data protection side said, data is not a counter performance because we don't know the relation with the general data protection regulation. This is a contradiction to it, to the data protection. On one side you say, okay, the data is an asset, we give it away and someone can pay with that. On the other side we say, it's a privacy protection. Very difficult. And the legal classification is unclear. Can the entrepreneur have a claimable right to receive data? Or when you can cancel the contract, for example, I give fake data, for example, to Instagram. I give a fake name or fake age. Is that infringement of the contract, and can then Instagram cancel the contract because I gave the wrong data? Very difficult. Nobody can say in a moment. And the general problem is the commodification and monetization of personal data. Yeah, this is a legal ethic problem. Can we monetize the personality and especially the private data in that way? And that is very difficult. So the legal consequences are clear. It's a problem for the data protection. It is not yet totally coordinated with the data protection right, so there is still the ambivalence. On the one side, we must keep the market open by letting the companies giving access to other companies to the private data they collected. On the other side, there is a limit by the interest of the private individual to not spreading the data to other companies. So you see the ambivalence of the data in markets and of the data protection, and the consumer rights, of course, cannot also not be infringed by that. Just because it's an economic asset and you pay with that, it does not mean that they can do with the data whatever they want. And that leads us to the question, what is the future character of personal data? How we can protect the data in that sense of economical functions of the data? And one idea, one approach is to understand personal data as an intellectual property right. So we differentiate between the data protection and the data property, and actually I'm the one who has the data and who can decide about the use of the data, and I give use of my data to a company. That would be something like licensing the use of my data as a licensing model, yeah? So, or they give me a honorary, or they give me a royalty, or they give me a counter service, but it is sort of a license. And this is actually an idea which is discussed in Germany, and this is the last slide here. I want to show you why this model is striking and very interesting. This I painted alone, yeah, because I'm not good in making slides, so I did that so freehand. This is actually an old idea of a German, one of my teachers in my study, Professor Forkel from Würzburg. He wrote his habilitation book in the 80s, or in the end of the 70s, about mother and daughter laws. Mother and daughter laws is a concept for the Hak Cipta, for the copyright law, because as you know, compared to the patent law or the trademark law, the copyright law is very close to the personality still. So if I write a book and I give you the license to use this book and or make a movie out of that book, and you change something which is not good for my honor as an author, I can forbid that. Yeah? So we have the moral right in the Hak Cipta, and we have this economical function of the copyright, which is in the license, given in the license, or given to the editorial or to the moving producing company. Now, as we have this moral right, and this is always combined with the person, 17 years after the death of the person it ends, but it will be always this moral right, this Hak Cipta personality right. We can talk about a mother right, and the daughter right is the copyright which you give to the company. So you make this little bubble, this is the daughter, and this bubble is given to the company, to the editorial, to the producer company which makes the movie out of it, to someone exploiting the copyright. This is the daughter law right you give to the company. But if something happens, if they misuse the daughter right and infringe my personality interest as the author of it, then the daughter right will be sucked in back into the belly of the mama. Ya, menghisap kembali kepada mama, kepada ibu. Ya, ibu will take it back, and then the one who misused the copyright doesn't have anything. So we can use this model also for the data, private data. Once they abuse my private data in a way which is not compliant with the rules of my personality or the idea of my personality, I can take the license back, and they are not able to use the data anymore. So this is the idea of the private data as a intellectual property right, and for understanding that, we could use 2 more hours actually, because this is dogmatically high interesting, because in property you always have this protection function, this exclusion function, and the use function. And actually here we only have the protection function, because you as an individual cannot use your data, you don't go to the market. If I ask you now, who should be the one who is the owner of the data? Is it the mining company? Is it you? Is it the refinery company? Who should have it? What is your opinion? What do you think? Me as who should be the one who has the property? If you talk about the American law or the economical analysis of law, we would say the one who is best able to exploit the data in a most effective way for the general welfare should be the one who use and decide about it. If we talk about more moral idea about the individualism, we can say economization of private data and functions of the private personality is always dangerous in the ethical sense, and we should take care that we not let the economy get too strong over the individualism. So we need an equilibrium in this. And to conclude that, you see, if you want to understand and if you want to study Indonesian data protection law, you should understand about this working together of these 3 directives, regulations of the European Union, especially about this fight of economy function and private function of the data, and understand that data protection law is not only protection in the forbidding sense, but is also exploitation, and exploitation or functions of economy can also be used for protection. And this is interesting. And my final remark is, maybe we need a totally new concept of data protection, because in the earlier times, people were very worried about their data. Nowadays, people share their data very free everywhere. You see your dead grandmother in the coffin, in the Facebook. You see your children, the people post when they eat that, and when they eat this, go half naked in the internet, and so on and so on. So maybe we don't want to be protected anymore, and maybe we need a more pragmatic approach to the data protection, and then maybe this economic approach would help a little bit to find a new way. So that's for all. I think that is enough. So you have a little bit an idea about how the data protection works, and also you have an idea about the special aspect of the data protection, because you cannot understand it without the economical function of data in the antitrust law also, and in the market structures. Thank you.
Thank you very much, Professor Koos. Okay. Yeah. Ladies and gentlemen, the introduction of data protection law has been chosen as the theme of today's general lecture, and Professor Koos has delivered his material, his presentation completely, and he has already taught us about the general data protection law, the general data protection regulation, some of the articles of GDPR, and he also taught us or shared about the difference between data protection law and data property law. It's very important. It's very interesting. And right now we enter the question and answer session. You could raise your question both in Indonesia and English. Okay. Would you like to answer one by one question? One by one question. Okay. All right. Okay. Indra. Ada mic yang ini.
Thank you very much for the opportunity to ask questions. So first of all, what great presentation that was. I really appreciate the matter. It is a great knowledge for me that is also interested in data protection law also, by the way. And I have 3 questions, if I may, because I have another question about data protection law. So first of all, about mutual assistance under Budapest Convention. Basically, is applied and is regulated under the Budapest Convention, and it's applied to
Under which convention?
Budapest Convention.
Human rights.
No, mutual assistance.
Mutual assistance.
Yeah, regarding the cyber crime.
Oh yeah.
All right. And however, it's only practiced in Europe, but it has not been practiced globally, especially in Indonesia. So my question is, what's the future of mutual assistance, especially in Indonesia, when we talk about extraterritorial cybercrime? Will Indonesia apply this concept for the data protection of Indonesians? And second, regarding the data transparency here, in Indonesia we have a debate regarding the right to land data transparency, and it's not for the private actor, but it's actually for public actor, especially here, the government. So the government justifies that the data for right to land data transparency, it has to be publicized for the purpose of environmental protection. My question will be, is it justified under, or is it a lawful justification under international human rights law? And finally, regarding the international humanitarian law, so we see that the cyber attack has been an option for a attack in humanitarian law. We see that Ukraine and Russia uses cyber attack before they're going into the war, the armed attack. Now my question will be, will private party or private actor play their roles in cyber security or even cyber attacks under international humanitarian law in the future? Thank you.
The counter performance can already be interpreted, if you want, in the current civil law, actually, right? Because maybe, yeah, the problem is, of course, the qualification of this data as asset. But we discussed that before. Indonesian law gives the opportunity in a certain way to qualify things as assets which have a value and which are exclusive. However, the problem in the data is the non-revolutionary. Maybe this is a difficult. So the contract law is subject to the collision, to the conflict of law rules for contract law. So if we see in the German law this is a counter performance for digital service, then it can only be applied if this purchase contract is under the German law. And this is not under the GDPR in the extraterritorial sense. It is under the Rome I regulation, which says that the law is applicable to a contract where the one with the characteristical performance has a seat. And if the company is selling you this service and has the seat in Germany, it's applicable. If it's the US, maybe not. But however, if it's a consumer contract, then it would be applicable to European law, and it's applicable. But it's not so easy with the extraterritorially in this sense. Will Indonesia adapt it? I don't know. I think so, because in the digitalization it will be inevitable to assess whether digital data or how to pay with data, because this is, of course, as we see, the economical reality that people pay with data. Otherwise, it would not be understandable why we have so many services without any payment. Nobody gives us something for free, right? So this is the reality. So it will have to be discussed, and I'm sure it's already discussed, because the research in Indonesia is quite advanced in the digitalization, as I understand that. The second question was about, can you help me?
The right to land data transparency. So Indonesian government decides to. So the Indonesian government decides to publicize the personal data of the owner of right to land in Indonesia. So
The owner of what? Of right?
Right to land.
Oh, right to land.
Yeah, in Indonesia.
Oh yeah. I don't know that they do that. But if there's a public purpose for that, it could be reasoned by this. I don't know how it will be under the new regulation. But what is the purpose of this publication? Oh, this is the publicity principle. The publicity principle, like in this book, right, where the owner of the right is written. This is of course justified. Yeah, we also have that. However, I don't know. You make that in the internet? Is publishing? No.
So basically, under Indonesian law, we have a UKIP. So keterbukaan informasi publik, or in English it will be public information transparency. So under that Indonesia government uses that specific act as the justification to publicize the.
It has a good purpose, right? It has a good reason, because the publicity of who is the owner of the right is very important, and it's a big issue in Indonesia. For example, I was planning to buy land in Lombok some years ago, and I did not dare, because I learned that it is very dangerous to buy land, because you never know who is the owner. So someone sells you something, then you must put a sign on the ground, and then there must written is bought by someone, and then there is some period where someone can come. No, I'm the right owner, the real owner, and then there is no clearness about who is really actually the owner, and then my money is gone and I don't have anything. So actually there's a good reason for that, right? To make transparency who is the owner, because it is very important that in our legal system to prove who is owner, and in the future will be very interesting, because that is why your question is so interesting. I read a discussion about saber notary in Germany, and the notaries were discussing whether the blockchain technology will change the purpose of the notaries in the future. And then the question is the proof of the ownership of land, which is written in the blockchain. But the blockchain is also actually a data storing, right? The blockchain is data storing. So this is actually the issue which will arise when we have the blockchain, digitalized data storing of ownership, and also who was the owner before and how long will it be in the blockchain. It will be eternally in the blockchain. And the third question is about cyber crime or cyber bullying.
The cyber attack. So my question is, will private actors play their roles under international humanitarian law?
Yeah, I never thought about that, but of course the hackers and the activities of private actors, the meaning or the importance of them is raising. We will have in the future maybe not even human actors here, because we see here already that algorithms are attacking already, and then we will have counter algorithms, and these algorithms will be substitute fighters, for safety and counter safety. I think this plays a big role, and we are not so sure. Actually, we cannot prove who exactly is behind these cyber attacks. We will know it comes from certain countries. Sometimes maybe the software comes from certain country, like this Pegasus Trojan come from Israel and is used by a lot of governments. And the cyber attacks from Russia, of course, it is in the interest of Russia, and we were relatively sure that Russia is using this as a cyber war instrument. But it is clear that maybe these are private hackers used by authorities or by the government, or maybe they encourage them to do so. I'm not so sure if they really sit in the ministry and hacking around. So I think we cannot really determine whether that is coming from the private side or from state side. In any case, it is a question of hybrid war, right, which happens nowadays. We are in Europe, we are very worried that the war could be hot, later. But maybe the war will never be hot. Maybe the war will go more to that side, because we have already switch off of our train system because someone hacked here, and then you know that these pipelines are sabotaged, and then we have also the trains did not go because someone hacked that and hacked this, and then electricity could switch off. Very dangerous, and this is a sort of a new kind of war we have here, and I think there are private persons involved, but how to address that if it's abroad, right? Of course we can say it's forbidden, but you know that when I mentioned that what happened in Indonesia, hacking your government, and then the government said, please don't do that anymore, but who hacked them? Was it the state? Was it another government? Was it private people? Was it some prank? I don't know, and I don't know if it's enough to say please don't hack us anymore, So I think we should fight against it with the same instrument. Maybe also have good hackers who are good in that, But you know, in Germany it's difficult, In Germany everything must be legitimized by the law, and you cannot say, hey, you're a good hacker, come on, hack the Russians, I think this is very difficult in the German authority to order some hacker to do that, yeah, and maybe the Russians are more flexible in that. But again, I have no idea who really did that, but of course it is their interest, and we don't know who is always behind these things. We don't know yet who made that with the pipelines. The Russians say the British were it, or the Americans were it. The Americans say the Russians were it. The Swedish say nothing else. I don't know. Nobody knows yet.
Thank you so much, Indra, for the question. Give an applause. Boleh berikan tepuk tangan buat Indra. Sekali tanya langsung borong ya. Okay. Based on your second question, I remember when we learn about English law, Memoria taught us about when we want to buy land, we have to remember and we have to search, is there any cloud? Do you remember him? Do you remember it? Ya. Jadi kalau mau beli tanah kan mesti search ada cloud-nya atau tidak. Cloud means it doesn't mean awan, but ada nggak sesuatu yang menghalangi tanah itu clear or not, gitu ya. Jadi itu publicly ya, terpublish di kantor pertanahan. So we have to search about.
Germany is very easy. If I buy land, I look into the ground book, das Grundbuch, and there is written who is the owner. And if that one is not the owner because the authority who makes that register is made a mistake, then I have the good faith in the property of that one who is written in that. And we will have that also digital in the future. There will be the digital registers, and this is actually the same issue, but there is a good reason for processing the data digitally, yeah? Also in the interest of the one who is the owner of it.
Yeah.
But it's very easy. In Germany it's very easy, but we have now property, but we did it now from a developer in Jakarta, a trustable developer. I would never buy from private because I have no idea. And your law is so complicated because then we did not have yet this postnuptial agreement, and then I must make hak guna and all these things, and then you have all these this third person in it, and I didn't trust that. So I was warned to do that, and I don't understand it. But obviously, it's important to have a clear idea who is the owner, right? So there is a good purpose for exception.
Are there any other questions, guys? Ada yang punya pertanyaan lain? Tidak? Boleh dalam bahasa Indonesia? Kayaknya ada beberapa mahasiswa saya yang harusnya kuliah hari ini jam 1 nih karena asinkron terus datang. Are there any questions? Is it clear enough what Professor Koos has delivered to you? Ngerti nggak? Ada yang ingin ditanyakan nggak? Okay, maybe I will raise a question, Professor Koos. We just discussed it before yesterday, and you have mentioned some of this issue on your presentation. What do you think on what is your opinion about the data protection law in Indonesia? As we know that we have not the data protection law yet. It's just RUU, Rancangan Undang-Undang Perlindungan Data Pribadi. So we have not the fixed regulation, its own process. So what do you think? Kalau tadi sudah disebutkan oleh Profesor Koos ya, saudara, salah satunya di RUU kita tidak menyebutkan tentang yang tadi by default dan yang satunya tadi, Prof. Okay.
It would be not fair to criticize the draft before I have read it, yeah. So I did not read the draft yet. Because it's very difficult sometimes to find publication of drafts of regulations in the internet in Indonesia. This is a little bit more difficult, more easy in Europe. There, all the drafts are always published, and so. But today, this morning, I found the draft indeed, and I will translate it. But I have from second hand. I read an article in the Jakarta Post about that. Very interesting, very good article, by the way, by an Indonesian researcher who was studying in Leiden, and she exactly criticized what I mentioned. That it is like the European data protection regulation, quite modern. Yeah, but this data by default and the data by design is not integrated. I don't know if that is true. I will check that out because we prepare professional courses for data protection here, the training courses, also for other universities. And if that is the case, that would be maybe a basic problem, yeah, because the data by default and the data by design is maybe the only or one of the more important ways to protect the data. Because if you think about these devices coming from other producers from China or Taiwan or whatever, then it can be used in the wrong way, because they collect a lot of data, and before we leave these products into the country, we must make sure that they best protect our interest, and this must be in the design, in the technology already. So the importer must already do that. If that's not the case, then you have a lot of issues like with this dark pattern of this. But I cannot really criticize that, because what I understand is it's very similar to the European Data Protection Regulation, and that turned out to work fine. And if you ask me about the chances that this regulation is applied in a proper way, I think it will, because Indonesian market, again, I said that before, is important market. And so I think it will be respected. And you know, the more of these kind of regulations we have worldwide, the more it is worth it for the platforms to comply with these rules, because it's not only the European Union now, it's also Indonesia have these, also other countries have similar data protection regulations, so they will have to comply globally, because of course it is not so important that North Korea maybe doesn't have a data protection regulation, and China is anyway a special thing. They have a big common market themselves, so they make it their way, but maybe also they will adjust to it sooner or later, we don't know.
Thank you so much, sir. Thank you so much, Professor Koos. Are there any other question? Alright, sepertinya tidak ada pertanyaan lain, Prof. Jadi dari Indah mewakili semuanya, sekali tanya langsung 3 pertanyaan. Or maybe from the lectures, are there any questions? Oh, tidak ada. Baik, it's very nice to have all of you guys in this general or public lecture. Thank you so much for all the participation and the attentions. I hope, or we hope, you found this presentation are informative and helpful. And I just want to say that some years ago, maybe when I was a student, I attended the general lecture, and we have Mr. Kaltan Benvan from Singapore as the speaker. Mr. Kaltan Benvan from the Singapore said, learning is a process. How to be able to do something we cannot do before we learning. Jadi moral message-nya adalah kita belajar dari siapa saja. We learn from everyone, and we learn in everywhere. Kita belajar dari setiap orang dan di mana saja. Jadi saya berharap apa yang disampaikan oleh Profesor Koos tadi sangat memberikan inspirasi bagi saudara untuk belajar lebih. Saya tidak berharap saudara hadir di sini karena diwajibkan oleh Ibu Kaprodi, tapi sungguh-sungguh punya learning spirit, ya.
Yang paling penting adalah, mungkin Anda sudah nanti lupa semua, ya. Tapi yang terpenting adalah belajar hukum comprehensively. Tidak belajar hukum di judul satu. Judul saya sudah bilang itu yang terpenting. Saya bisa bilang itu semua dan setiap kali di setiap tempat, dan karena saya juga bikin mistake salah itu juga kalau saya mahasiswa. Jika saya mahasiswa, saya mau belajar civil law, mau belajar ini dan ini, tapi saya tidak mengerti tidak mengerti ada banyak connection terkait antara semua, ya. Dan untuk yang terpenting itu belajar rules, principles which are comprehensive for all. So you can learn a lot from here. For example, about organizational responsibility, about these things, about material, immaterial, about functions of the rights. And if you do that, and yang terpenting itu juga tahu tentang ekonomi, tentang IT. Tanpa itu lawyer nanti tidak bisa kerja lagi, ya. Di abad nanti ada lawyer harus program, harus mengerti bagaimana algoritma, bagaimana smart contract, bagaimana blockchain. Smart contract akan ganti semua. Kalau kontrak sekarang tidak masalah, bisa nego-nego dan bisa menulis kontrak itu, dan kalau menulis ada salah dengan menulis ada masalah, ada mungkin damage repair ya dari klien. Tapi nanti ada smart contract harus program. Kalau program salah, masalah tidak di enforcement kontrak, masalah sebelum kalau program, in the process of programming. So the lawyer and the notary of the future will have a totally different kind of work. This is why you must learn not only about the law, you should go to lectures of economy. You should understand about the new technology. Even me, I don't understand enough about technology. But what I understand is that without knowledge about economy, for example, economic function, you cannot do the law of your future anymore.
Okay, thank you so much. Okay, we have had productive and informative presentation from Professor Koos. Thank you very much, sir. And right now, I want to give it over to the Master of Ceremony. Thank you so much and see you on the next public lecture.
Okay, so that is all for the event for today. And thank you for Professor and thank you for Miss Eti. Thank you so much for everyone who has already attended this meeting. And also I would like to see you in the next event that we have. Thank you so much. Everyone is very welcome to leave the room. As well as the professor and Miss Eti, also the lecturers. Thank you so much, everyone. See you.